where is the question formulated that we should set aside a particular judgment?
Yes.
We are proceeding on the premise, as we are also sitting in appellate court. We know distinction between 143.1.
Yes.
We know the scope of 143.2.
Yes.
We know Cauvery and 2G scan, the distinction drawn. We are not here on 131. We are in within the parameters of 143.1. And the only issue is that whether the questions raised have been answered or not.
Well, this is the important nuance. The nuance of 2G is that the phrase, these are not my words, the Supreme Court words. The decision cannot be changed. The view of the law may be changed. Right, Wallace? No, just give me. Now, let me answer Justice Suryakant's query. No, just let me answer. My Lord Justice Suryakant says to me that we will not be touching that decision. Unfortunately, Malas, this is one rare case where both the decision of the case and the view of the law fuse. Let me explain that. There is a complete intersection. Your lordships can't do one without doing the other. And if one is prohibited, the other stands prohibited. Your lordship, all the questions except the peripheral ones 11, 12, 14, if answered other than the way in which the division bench answered it, will constitute a change of law, but a change of law also in the decided case of Tamil Nadu. Because for the simple reason, your lordship's advisory law, which is binding, once your lordship delivers 143, it's a question directly arising, I'll give the judgment. Your lordship's views, because your lordship is the Supreme Court, I can't seek your lordship's advice and disregard it.
Pre and post constitution principles are well settled.
Yes.
143.1 or a principle which was earlier to that effect, it is advisory in nature, purely advisory in nature, may or may not be accepted by.
No, Malas, that's not the law. Unfortunately, that's not the law. Malas, unfortunately, I would say it's not the law because your lordship doesn't give advisory jurisdiction in futility. Malas, therefore, let me just now turn to. So let me say this. Your lordship's view, whatever your lordship view takes in 143 is binding. Let's be very clear on that. Second, your lordship's, Malas, is not, to answer the Honorable Chief Justice, this is not perennial. A matter is referred, the law will change for the future. If a matter, Malas, to give a small example, Malas, Honorable Chief Justice, remember yesterday a matter came. Suppose in an appropriate matter, your lordship refers it. A constitution bench constituted by my lord's reference in that case may decide the law ultimately. It can't be in 143. We are discussing maintainability of 143. 143 is not maintainable. Now turn to Cauvery, Malas, very quickly. Malas, Cauvery, well, otherwise, kindly consider the institutional implications for having advisory jurisdiction on a matter which will change the decision between parties. It becomes a pure intra-court appeal. It becomes a pure review. It becomes a pure curative. Well, if I win on the merits, nothing else.
The point you show us one judgment,
yes,
which says that once there is a judgment of a division bench, the reference under 143 is not tenable.
Kindly, let us first see this judgment. Because we are talking about advisory. Come to para 19 at page 5429. 5429. Changes can be made, Balas, only in another matter for the future, not Balas in an existing case.
So that's the issue. We are not deciding as to whether Tamil Nadu judgment is correct or not. We are not deciding that issue. We are only answering the reference made by the precedent.
But in the event your lordship's answers are not consistent with the Tamil Nadu
matter,
then it becomes a different matter.
We are not concerned with that. It's an advisory jurisdiction.
Very well. Let me just read first Cauvery.
So that judgment which says that the reference is not tenable once there is a judgment by 2 judges or 3 judges.
Yes. Let me show whatever is there very quickly. 2 judgments only, Balas. Come to 19, where Balas, the tribunal held against Tamil Nadu, the Supreme Court allowed the appeal in 19. Ignore all that and come to Malas, straight away para 25, where Karnataka instituted a suit. Let me come to the relevant part.
Yes.
This court by its decision of April, Justice Nath has got it? Yes. Chandukar has got it. This court by its decision of April 26, this April 26 is para 19, my lord, the right on the side, para 19, has held as pointed out that the central government had made a reference to the tribunal for the consideration of the claim for interim relief prayed for by the state of Tamil Nadu, and hence the tribunal had jurisdiction to consider the said request being a part of the reference itself. Implicit in the said decision is the finding that the subject of interim relief is a matter connected with the relevant water dispute. Now see from here, Malas. Hence, the central government could refer the matter of granting relief for adjudication Although this court by the said decision has kept the open the question whether the tribunal has incidental, ancillary, inherent or implied power to grant interim relief when no reference for grant of relief is made, it has in terms concluded the second part of the question. This was the earlier judgment of the Supreme Court. It has in terms concluded the second part of the question. We therefore cannot countenance a situation where question 3 and for that matter question 1 and 2 may be so construed so as to invite our opinion on the said decision of the court. That would amount to our sitting an appeal on the said decision, which is impermissible for us to do even in adjudicatory jurisdiction. Nor is it competent for the President to invest us with an appellate jurisdiction over the said decision through a reference under 143. Mr. Nariman contended, however, that the President can refer any question of law under 143 and therefore also asked this court to reconsider any of its decisions. That is the direct argument. 143 is quoted. 85. In support of his contention, he referred to Delhi laws. Next line. For the reasons which follow, we are unable to accept this contention. In the first instance, the language of 143.1, far from supporting Shri Nariman's contention, is opposed to it. The said clause empowers the President to refer for this court's opinion a question of law or fact, which has arisen or is likely to arise. When this court in its adjudicatory jurisdiction pronounces its authoritative opinion on a question of law, it cannot be said that there is any doubt about the question of law or the same is res integra, so as to require the President to know what the true position of the law on the question is. Directly on point with us. The decision of this court on a question of law is binding on all courts and authorities. Hence, under the said clause, the President can refer a question of law only when this court has not decided it. The query asked from me, Mills. Secondly, a decision given by this court can be reviewed only under 137. When further this court overrules the view of law expressed by it in an earlier case, it does not do so sitting in appeal and exercising an appellate jurisdiction over the earlier decision. 5 judges are saying this was. It does so in exercise of its inherent power only and only in exceptional circumstances, such as when the earlier decision is A, per incurium, or is delivered in the absence of relevant or material facts, or if it is manifestly wrong and productive of public mischief. Under the Constitution, such appellate jurisdiction does not vest in this court, nor it can be vested in it by the President of 143. To accept Shri Nariman's contention would mean that the advisory jurisdiction of 143 is also an appellate jurisdiction of this court over its own decision between the same parties, and the executive has a power to ask. If such power is read, it would be a serious inroad into the independence of the judiciary, because the judiciary includes that division bench, this court, everybody. Next, 2G nuance, because that is the main thing which is alleged to have diluted it. Turn to 2G, Mills, which is at page 8123 of volume 5.21. Volume 5.21. So this is crystal clear. Some nuancing was done in a subsequent judgment. So let me place that. 5.21, page 8123. Justice D.K. Jain wrote the main judgment, Mills. There's a concurrence, but I'll only read Justice Jain.
Para 64, 65.
No, but that's correct. That's correct. But there are one or two more paras, Mills. 8157, it starts. The principal objection to the maintainability of the references, it's an indirect endeavor to unsettle and overturn the verdict in 2G, which is absolutely impermissible. The stand of the objectors is that 2G case is an authoritative precedent in respect to the principle or proposition of law that all natural resources are to be disposed of by public auction. Right. Now, Mills, remember, Mills, in this case, in the Constitution bench, the only issue was whether only way of disposal is auction, because only word is important. Otherwise, it's okay. They were considering an issue not really considered by the earlier bench. At the outset, we may note that the Attorney General has more than once stated that the Government of India is not questioning the correctness of the directions in 2G case. Kindly mark this. Learned AG is certainly not doing it here, but I mean, this is the law. This is why your Lordship doesn't open a decided case. This is what Justice Suryakant is saying, we're not going into the case, but indirectly your Lordship is invited to go into the case. That's the whole contention. So here in that case, the learned AG is not questioning the correctness in the 2G case insofar as the allocation of spectrum is concerned. And in fact, the government is in the process of implementing the same. That's not the case here. That's why 2G nuance is not against me. 2G held because another question was raised. Only way of disposal is auction, which was decided anew. It was not a decision on the old matter at all. Therefore, in the light of the said statement, we feel it would be unnecessary to comment on the submission that the reference is an attempt to get an opinion to unsettle the decision and direction of 2G. Nevertheless, since in support the opinion of Cauvery is cited, therefore we will deal with it. Now come to para 42.
Actually, you can come straightway to para 65, that probably answer what you are.
True, Malad, just 5 minutes extra it will take. I'll just, because otherwise, Malad, just 5 minutes extra it will take. 42. 42. Now, Malad, Cauvery is cited over 4 paras. I only want to, I'll not read it. My lord is right. To say that there is no intent in 2G to overrule or dilute Cauvery. Don't read, Malad, 5 judges in 2G to intending to overrule or dilute Cauvery. Nowhere is there an intention. Now come to Malad. The findings of Cauvery are reproduced in 42 and 43, fully, 42 and 43. Then comes the heart of the distinction, which is between view of the law versus decision of the case. Come to 43 verse. 45. 45. That's the heart of the nuance. Please apply the nuance in another case, not in this case, fellows, is what I'm submitting. The main emphasis of Mr. Soli Sorabji, do my lords have 45 verse? May I read? Was on the second part of para 85, which according to him prohibits this court from overruling a view expressed by previously. We are not persuaded to agree with the learned senior counsel. The paragraph has to be read carefully. Justice Sawant first considers the case of a decision of this court, whereas in the subsequent sentence he considers a view of law expressed by the court and attempts to explain the difference between the approaches of these two questions. These words are sometimes used interchangeably, but not here and above. We believe that Justice Sawant consciously draws a difference between the two when further this court overrules the view of law after discussing the case of a decision. Then come to 47 to save time, although 46 is important also. Blacks explains the difference. 47. Therefore, references in para 85 of Cauvery to decision and view of law must be severed from each other. The learned judge observed that in a case of a decision, let me first read, then I'll make my comment. The first limitation is that a decision of this court can be reviewed only under 137 and curative in no other way. I'll leave that because I'm doing speed reading. Please note the principle of Cauvery is reiterated. Now, Malats, if you say per incurium or Malats completely different, the burden obviously lies with the state. Now come to 49. 49 is the conclusion on Cauvery, which is decision versus view. The conclusion is 56, Malats. Well, the problem is that your lordships, try as you might.
Why would you come to 65? It's directly answer. Not necessary that all those paragraphs, small 5 or junior have to be read.
No, Malad, I'm not even reading half of them, Malad, I can assure your lordships. 63, Malad, and then 65. From the aforesaid analysis,
Yes.
it is quite vivid that this court would respectfully decline to answer a reference if it is improper, inadvisable, and undesirable, or the questions formulated are purely socio-economic or political reasons which have no relation, or are incapable of being answered, or would not subserve anything, etc. Or it is already decided the question referred. Already decided the question referred. That's an important sentence in 63. Then, Malads, come to 65. We are therefore of the view that as long as the decision with respect to the allocation of spectrum licenses is untouched, that was the decision of the previous court.
Understand that.
This court is within its jurisdiction to evaluate and clarify the ratio of 2G. For the purpose, it needs little emphasis that we have jurisdiction to clarify the ratio of 2G, irrespective of what we actually choose to do so or not. Therefore, the fact that this reference may require us to say something different to what has been enunciated in 2G cannot strike at the root of the maintainability. Consequently, reject the premium. Right, Wallace? Let's apply this. I have no problem. The problem between this case and my case, the difference is that in my case, if your lordship differs with the heart of the reasoning of the previous judgment, your lordship will be disturbing the decision of the case also. In my case, unlike this case where the decision of the earlier court was implemented in letter and spirit, but the law for the future with only one question was changed. Is auction the only way of disposal? The word only was said, no, there are other models of disposal. That's about it. That's, if your lordships can find a way without disturbing Tamil Nadu to reset the law, I could have no problem with it. I can't. But according to me, the nature of the case is such that your lordships would have to disturb the decision inter parties adjudicated between the parties without which your lordships can't do it. That's the whole thing.
Mandamus or whatever, if you call it a mandamus and the declaration
Yes.
that followed in that case has actually happened. So therefore, the question of our opinion having a bearing on a decision taken does not apply here. It's only an opinion. And we have seen in many cases, in a subsequent case, when you refer an opinion of a court and ask the court to take a different decision as against the previous one, many a times the argument was that this can't be relied on because it's only an opinion. That is what would happen. If somebody would argue on the basis of a decision rendered on an opinion,
Two things.
then it will be only.
Tamil Nadu, the governor is supposed to, I'm giving a very practical example, is supposed to do ABC. He's supposed to decide in 3 months. Your Lordship's law tomorrow will change it for Tamil Nadu also in the future. That's about all there is to it.
Yes, thank you.
Obliged.